Good morning. The subcommittee will come to order. Without objection, the chair is authorized to declare recess at any time. We welcome everyone to today's hearing on the Foreign Intelligence Surveillance Act, FISA. I will now recognize myself for an opening statement. Again, I welcome my colleagues. Thank you for being here. We're trying to beat a vote time, so we want to get as much done as we possibly can before that is called. If we're not finished, I'll let you know that we're planning on coming back following the vote series if we still are engaged here. I thank our witnesses very much for being here. Appreciate you being here as well. Congress enacted the Foreign Intelligence Surveillance Act in 1978 in response to revelations that the federal government had seriously abused warrantless surveillance, resulting in rampant privacy violations. 45 years later, the same remains true. Despite efforts to rein in these abuses, the federal government continues to use its powers to illegally spy on American citizens. The federal government uses your tax dollars to spy on you using a law called the Foreign Intelligence Surveillance Act, or FISA. In 2019, Inspector General Michael Horowitz exposed the extent to which the FBI violated its authorities under FISA. IG Horowitz identified significant concerns and serious performance failures, including numerous factual misstatements and omissions in the FBI's unjustified investigation of Trump campaign associates. In 29 applications that the FBI made to the FISA court to authorize surveillance, IG Horowitz found in 25 of them there was unsupported, uncorroborated, or inconsistent information, totaling more than 200 instances where the applications were inaccurate, unsupported, or omitted information. The FBI was unable to even locate the Woods file, for the other 4 applications. So the 29 couldn't even find 4 Woods files, and found over 400 instances of noncompliance with Woods procedures across the 29 application sample. In February 2020, Director Wray testified before this committee and told the American people that they should not, quote, lose any sleep over the vast majority of FISA applications. Former Director Comey labeled FISA a top-tier FBI program, but upon further review by the Inspector General, it was revealed that the FBI failed to recognize the significant risk posed by the systemic noncompliance with the Woods procedures, which provide the factual justification for FISA applications. In May of this year, Special Counsel John Durham released his report on the FBI's Crossfire Hurricane investigation. That report not only backed up Inspector General Horowitz's findings, but also found that political and confirmation bias by FBI employees led the FBI to lie to the Foreign Intelligence Surveillance Court and illegally spy on the Trump campaign for an entire year. In the recent investigation of Special Counsel Durham, he found that some FISA applications ultimately arose from sources close with the Kremlin who were known to be targets of ongoing U.S. investigations related to fraud and espionage. Durham concluded that the FBI ran with the first justification it found to spy on the Trump campaign, despite clear indications of foreign unreliable sourcing. These reports detail only a fraction of the government's abuses of the FISA program. At the end of this year, Section 702 of FISA will expire. Section 702 does not require a warrant or any other justification to an independent arbiter, such as a judge or magistrate, before the government agent can query databases about an individual who is a U.S. citizen. Reports in recent years have exposed the government's and specifically the FBI's abuse of this program. A law designed to provide tools to collect foreign intelligence and prevent terrorist attacks has been warped into a domestic spy tool that has been used millions of times over the past 3 years to target Americans. In 2021, the FBI queried the communications of over communications more than 3.3 million times and of more than 1 million discrete U.S. citizens. In 2022, the FBI conducted thousands of U.S. person queries. A recent FISA court opinion revealed that the FBI conducted more than 278,000 improper searches of U.S. persons' communications in 2022, including those of people who attended protests, 19,000 donors to a congressional campaign, and in another instance, the FBI looked at the communications of donors Think about that. 19,000 people on a donor list are being queried and looked at by the FBI simply because they did donate. As Congress considers whether to reauthorize this program, this committee will be at the forefront and has the opportunity to shed a light on the broad issue of warrantless mass surveillance in violation of the Fourth Amendment. We must consider whether FISA and Section 702 can be reformed or if it's beyond repair. I, for one, see no reason for members on either side of the aisle to trust the FBI with this tool. The FBI has used FISA, specifically Section 702, to spy on Americans, to violate the Fourth Amendment, and conduct warrantless searches. FISA 702, let's see here. It's clear that the government is using communications acquired through this program to conduct backdoor searches, which I think we'll hear more about today. Most of this is done without a warrant. Section 702 information acquired without a warrant can later be used by the FBI in criminal prosecutions unrelated to foreign intelligence or national security. The FBI has misused privileged spying powers to conduct rogue surveillance on innocent Americans, and we cannot allow that to continue. I have called for serious reforms or full repeal of FISA for years. I think it is built on a dubious constitutional foundation. The FBI has used this tool designed for foreign surveillance to spy on congressional donors, January 6 protesters, Black Lives Matter protesters, and even elected officials, including one of our own congressional colleagues. We must end warrantless surveillance of Americans and hold accountable any federal official who violates the civil liberties of Americans. Make no mistake, actors within the FBI and other similar federal agencies who continue to conduct unlawful and unconstitutional surveillance of Americans should be brought to justice. Some argue that these are no more invasive than a stop and frisk Terry stop, but at least in a stop and frisk, you have personal contact and actual communication between the target and the government agent. I suggest that even a 702 query is more akin to a wiretap, which requires a warrant before executing that query or that wiretap. The FBI claim now is that it's okay because it has put in place new protocols and new software. But unlike a warrant, all of the FBI measures rest ultimately on post-action review, and it's not by an independent arbiter. I continue to believe that we will be able to work across the aisle with our colleagues because so many of us agree on this issue, and I extend my hand to them and look forward to working with Ranking Member Jackson Lee and other members of this committee as we confront this serious issue. Again, I thank those on the panel for being here today. I thank our witnesses and those in the audience, and I yield back and now recognize the Ranking Member, Ms. Jackson Lee, for an opening statement.
Mr. Chairman, thank you so very much. I am very pleased to join you in convening today's hearing on the Foreign Intelligence Surveillance Act, or FISA. As I indicated during part one of our examination of FISA, this subcommittee has a critical role to play in the reauthorization of Section 702, which expires in less than 6 months. Let me acknowledge all of my colleagues that are present here today, in particular, Ranking Member Nadler. The two of us may be the only ones present that were here when the Judiciary Committee single-handedly had to put a pause on the Patriot Act and begin to address some of our concerns after 9/11. Even in that dastardly, devastating loss of life, it was important to recognize that we are a nation of laws and the Constitution, and to be able to respond at that time. I know that the thousands of agents across America have as their general premise to investigate crimes and as FBI agents and to follow the law and to protect the American people. That I will acknowledge. We had the opportunity to be briefed just a few days ago by members of the FBI, and I will acknowledge that there is a critical understanding of the challenges that we are now facing. But Congress is the arbiter of the Constitution and the responder to the American people and the protector of the American people's constitutional rights. With that in mind, this vital set of provisions under Section 702, which has been the subject of much scrutiny and criticism, permits the federal government to collect foreign intelligence targeting non-U.S. persons outside the United States without obtaining individualized orders. It is, of course, a unique provision. While I expect that today's witnesses will discuss many of those criticisms, I hope that we are able to have a constructive conversation about the ways in which Congress can make certain that U.S. persons are not ensnared in the web of international surveillance. I will look forward to their insight because we will act. Congress must act. Beginning with the Foreign Intelligence Surveillance Act, which first passed more than 30 years ago to address abuses in collecting and using foreign and domestic intelligence, the government must show not only that there is probable cause to believe the target of intelligence surveillance is an agent of a foreign power, but also that foreign intelligence gathering is the primary purpose of the collection. Following the 9/11 attack and significant advancements in technology, the foreign intelligence gathering needs of the country shifted considerably, yet were often stymied by the need to obtain individual FISA court orders for overseas surveillance, which requires substantial manpower, as presented to Congress by law enforcement. In response, Congress passed the FISA Amendment Act, FAA, of 2008 that authorized the federal government to collect massive amounts of information through the targeted surveillance of foreign persons reasonably believed to be outside of the United States without a warrant. Congress has granted agencies within the U.S. intelligence community this authority through FISA and Section 702 so that they may gather foreign intelligence information to seek out, pursue, and thwart threats from foreign terrorists and nation states that mean to harm us. Together, these statutes have been vital to the protection and safety of Americans. However, as we consider reauthorization of Section 702, we must be certain that we are not conceding very clear the constitutional rights of Americans in the name of national security. That is what makes America unique. That is what is the grounding of the constitutional pillars that are our definition. The FAA requires intelligence agencies to design targeting procedures to limit the scope of collection before the government acts, and minimization procedures to limit the use of information about U.S. persons after the government incidentally collects that information. The Foreign Intelligence Surveillance Court reviews these procedures for legal sufficiency. Although the statute includes protections for U.S. persons whose information is inadvertently collected but not constitutionally subject to targeting, we know that the NSA and DOJ have repeatedly reported the unauthorized use of backdoor searches of the 702 database. And as a release from the Brennan Center pointed out, internal oversight measures hailed as robust failed to prevent flagrant abuses, including 133 warrantless searches aimed at Black Lives Matter protesters and 19,000 searches for communications to a single congressional campaign. We're also faced with considering what guardrails are appropriate to prevent federal agencies from evading the legal protections of Americans' privacy by purchasing data from data brokers. These and other problems with FISA and Section 702 have led some of my colleagues, particularly Chairman Jordan and Chairman Biggs, and all of us, to take a position adverse to reauthorization of Section 702 in its current form. Since this is the second hearing of this subject, I hope that my colleagues are attaining sufficient information to help us reach a compromise position to move this reauthorization forward and to acknowledge that all of us have criticisms, but I think what is broken needs to be fixed. Given the threats facing our nation from the ruling Chinese Communist Party that represents both the leading and most consequential threat to U.S. national security and leadership globally, according to Director of National Intelligence Avril Haines, to terrorist groups such as ISIS, Al-Qaeda, and Hezbollah that continue to plot attacks against the United States, it is critical that we take appropriate action before the expiration of government authorities under this provision and simply make it right, make it correct, make it constitutionally infrastructured, if you will, to be able to function for what it is needed and to protect the American people. That is why I will reiterate my thoughts from part one of this conversation, We worked together to pass USA Freedom Act in 2015, demonstrating that we're capable of building consensus around our common values dedicated to privacy, transparency, and protection from unreasonable searches and seizures. Let us do so again together on behalf of the American people, reshaping these critical tools so that they serve the government's needs while also protecting the privacy of every American. I look forward to the testimony of our witnesses and yield back, Mr. Chairman.
Thank you. I thank the ranking member, Jackson Lee. And now the ranking member of the entire committee, Mr. Nadler from New York.
Thank you, Mr. Chairman, and thank you for continuing this committee's important work on FISA reauthorization and on the overall question of the warrantless acquisition of U.S. person information. At our last hearing, we heard from government watchdogs who described the FBI's ongoing compliance issues with Section 702. Today, I hope to hear from the witnesses about the impact of these violations, even when they are unintentional, and about what changes this panel believes would make inappropriate queries of the 702 database all but impossible. As I said at the beginning of our last hearing on this topic, I have never voted to reauthorize Section 702. I am deeply uncomfortable, as we all should be, with the legal fiction that it is permissible for the government to search our most private communications without a warrant simply because they were aiming for non-U.S. persons overseas. I understand, however, that this authority has become increasingly important to our national security, and so I will entertain reauthorizing Section 702, provided that we meet this basic privacy challenge head-on. Although Section 702 authorizes only the targeting of non-U.S. persons who are outside the United States, we know that massive amounts of U.S. person data are swept up under this programmatic surveillance. We also know from what reporting is available that the government has a lot of this data, and that much of it could not have been obtained without a warrant had they tried to collect it directly. As the reauthorization debate has begun in earnest, the FBI has assured us that they only receive a small percentage of the total information collection under Section 702. We cannot discuss precise numbers in this setting, but nobody should take comfort in the fact that the FBI only has access to some portion of a staggeringly large volume of information, including vast amounts of data about U.S. persons. The FBI has also demonstrated, after 2 decades of tinkering with the system, that improved training and the reconfiguration of their database has reduced the number of improper queries of Section 702 information by roughly 90% this past year alone. That is no small feat, and I wonder where this debate would be today if the Department of Justice and the FBI had taken their noncompliance problems seriously years ago. But again, it is difficult to find comfort in the percentages. If 2 years ago there were 2 million improper queries, and last year there were only 200,000 improper queries, we are still left to contend with 200,000 unsuccessful attempts to sidestep our constitutional protections. In a recent briefing, the FBI and the Department of Justice told our members and our staff that one cause of noncompliance was a simple misunderstanding, in quotes, of the legal standards under Section 702. That was their term, misunderstanding. I have no doubt that FBI personnel and field officers across the country may have had trouble interpreting the law, and I am pleased that the administration has corrected course, but I find it deeply troubling that the FBI would blame its field officers for a problem that clearly originated from its leadership. Let's tell the story as it actually happened. Congress last reauthorized Section 702 in 2017. Over the course of the next few years, DOJ and the FBI diverged on how to interpret the legal standards for searching the Section 702 database. The FBI told us at the time that it was perfectly appropriate for the Bureau to take a looser view of the statute, an approach that ultimately gave them more access to our private communications. This was no misunderstanding. It was a deliberately maximalist interpretation of the law. The scathing FISA court opinion that has been released since our last hearing, the one that showed the FBI querying the database for particular campaign donors, George Floyd protesters, and January 6 suspects, is a direct rebuke of that interpretation. I understand that the FBI has since corrected course. I'm deeply gratified that the leadership of the Department of Justice took control and decided to adhere to the limits Congress put in place. But this so-called misunderstanding really gets to the heart of the matter. Chairman Biggs and I agree on very little. But here is one place we agree. Whatever we think of the last administration, whatever we think of the current administration, we cannot count on the next administration to get this right. We have to build a Section 702 regime that fully respects our privacy, no matter who is in charge. Not 90% of our privacy, all of our privacy. The changes the FBI has made to this program in the run-up to reauthorization are welcome, but they are insufficient. I look forward to hearing from our panel today about what else we must do to correct this program before it can be reauthorized. Thank you, Mr. Chairman, and I yield back.
Thank you, Mr. Nadler. Without objection, all other opening statements will be included in the record. We will now introduce today's witnesses. I'm very excited to welcome this august panel. Professor Jonathan Turley. Professor Turley is the J.B. and Maurice C. Shapiro Professor of Public Interest Law at the George Washington University Law School. He's a nationally recognized legal scholar who has written extensively in areas ranging from constitutional law to legal theory. Thanks for being here, Professor. Mr. Phil Kiko is a principal at Williams & Jensen PLLC. He is a former Chief Administrative Officer of the House of Representatives and has served in a number of positions with members of Congress and committees, including this committee, the Judiciary Committee. Thanks for being here, Mr. Kiko. Mr. Gene Shar is a partner at Shar Jaff LLP and serves as the General Counsel at the Project for Privacy and Surveillance Accountability. The Project for Privacy and Surveillance Accountability advocates for greater protection for Americans' privacy and civil liberties in government surveillance programs. Thank you for being here, Mr. Shar. Ms. Elizabeth Goitain, am I close? Okay, Goitain, okay. Ms. Goitain is the Senior Director of the Brennan Center for Justice's Liberty and National Security Program. Her work focuses on presidential emergency powers, government surveillance, and government secrecy. We welcome each of you here today. We thank you for appearing. I think we're all very excited to hear what you have to say, particularly potential remedies and recommendations. We will begin by swearing you in. If each of you would please rise and raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you are about to give is true and correct to the best of your knowledge, information, and belief, so help you God? Let the record reflect the witnesses have all answered in the affirmative. Thank you. Please be seated. And please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony in 5 minutes. I will begin tapping just before that 5 minutes so you are aware that your time is about to expire and the floor will open up and your chair will disappear. No, that really won't happen. I can't believe I said that. I'm not filtering. Anyway, I'll try to filter. Professor Turley, we recognize you for your 5 minutes.
Thank you, Chairman Biggs. Thank you, Ranking Member Jackson Lee, and thank you, Ranking Member Nadler, and all the members of the subcommittee. It's an honor to speak to you today about FISA and the reauthorization of 702. Today's hearing will raise admittedly difficult legal questions, and there's some questions, however, that should not be in doubt. There's no question that the FBI and other agencies have continued to defy federal law and abuse their powers under FISA. There's no question that both the courts and Congress have been misled in the use of FISA in prior years. There's no question that the scope of the harm to privacy and constitutional rights has been immense. The only question is what you're going to do about it. And I think it is a significant moment in today's deeply divided politics that not only are the witnesses on this panel largely united in our views, but it appears that many of the members of both parties are as well. Quite frankly, the FBI is back once again at a reauthorization, as Ranking Member Nadler mentioned, saying that you can trust us. And for those of us who have been critical of FISA, it is an exercise of really breathtaking audacity, including, as Congressman Nadler stated, the continued reference to misunderstanding laws after years of litigation and discussion of those laws. If we reauthorize Section 702 without significant changes, then we have become a nation of chumps. It's not like this is being held from us as facts. We have documented evidence of massive violations of the privacy of U.S. citizens. So this is not something that is being hidden. It's in plain sight. Now, obviously, one of the possible responses from Congress can be simply to let this provision sunset. You just go back to the way it was in 2008. That would convey an important deterrent for agencies that if you abuse it, you lose it. And this would certainly warrant that type of response. But assuming that you want to add guardrails, there are a number of things that I've suggested in my written testimony. My colleagues have recommended others in theirs. These include ending backdoor searches, strengthening minimization standards, barring parallel construction, dealing with commercially available information as a circumvention of constitutional protections, and the creation of special advocates in the FISA process. You know, when Ronald Reagan famously talked about the Russian proverb, trust but verify, we actually have our own such proverb or viewpoint, and that was contained in Federalist 51, when James Madison said, you can never have government where you trust on the good motivations of the government itself. This was part of his discussion that if all men were angels, no government would be necessary. And he said that the key to good government was to oblige the government to control itself. FISA fulfills Madison's worst expectations. That trust has been repeatedly violated by the FBI and other agencies. And so once again, I ask, what are you going to do about it? Now, government power is a lot like gas in a closed space. If you expand the space, the government will expand evenly to fill it. If you allow a crack, the gas will escape. Section 702 wasn't a crack, it was a wide open door that allowed for these types of violations to occur, this pretense of incidental violations of privacy. I won't get into the specific details right now, but I'll be happy to talk about them. I do want to know, one of the suggestions that I make is for the creation of special advocates. As was mentioned earlier, this Congress did create amicus as part of FISA. That system was commendable, but it has been an utter failure in my view. We need the creation of a different type of advocate within the FISA system. Just as there are advocates to protect our security in FISA, there should be advocates protecting our privacy in FISA. And we need to create a firm, structured role for that. In many ways, the Vatican had the devil's advocate that often had to present evidence against the wishes of the Vatican. We have to have the same process in FISA. Thank you very much for the opportunity to speak today, and I'd be happy to answer questions.
Thank you, Professor Turley. Mr. Kiko, you're recognized for your 5 minutes.
Chairman Biggs, Ranking Member Jackson Lee, and Nadler, it's an honor to testify before this committee. I was asked to share my experience in successfully assisting in crafting complex anti-terrorism legislation, in particular the USA Patriot Act and its progeny, and to provide some perspective associated with the issue of 702 expiring at the end of this year. A little background. Following widespread wiretapping and surveillance abuses, Congress originally enacted FISA to make sure that government agencies must secure authorization to gather foreign intelligence. In addition, FISA created 2 new Article III courts. The most significant later reforms in FISA was the enactment of the Patriot Act as a result of the attacks. The pressure on this committee to do something after the 9/11 attacks was enormous. However, the committee came together to consider all the options. Formal hearings were held to discuss new anti-terrorism authorities. We had a lot of unofficial late-night sessions, committee members sitting at the dais here. The committee sought input from everyone. The door was wide open to craft the Patriot Act. But one of this committee's top bipartisan priorities was to ensure that we protected not only our national security, but our cherished civil liberties. And that core principle has been the hot point of contention in every FISA debate. The Patriot Act provided enhanced investigative tools to prevent the future terrorist activities and the prevention of preliminary acts and crimes to further such. It amended FISA by creating 16 new authorities, and looking back, one of the best things Congress did was to incorporate the sunset provisions. The idea of sunsetting these authorities was not popular at the time, particularly with the Justice Department, but the Patriot Act would be enacted with its extraordinary new powers and safeguards to civil liberties. Only the sunset provisions were there to preserve Congress's power to change the law. Since 9/11, FISA has been amended several times, including the addition of 702 in 2008, and it created procedures to collect foreign intelligence when communications travel through the United States communication infrastructure. It was designed to target non-U.S. persons reasonably believed to be located overseas, and it was viewed as a vital tool to protect Americans, including our men and women in uniform. But have the law enforcement agencies and intelligence communities earned our trust to retain those expansive authorities? I would say the answer, I think, is no. My written statement goes into the problems in detail, and this committee knows more than ever the myriad of ways in which the failures have occurred. I should add, this frustration is not a partisan one. Since the leak of the Snowden documents, the public disclosure of abuses that resulted in the passage of the USA Freedom Act, we have continued to witness serious escalating concerns surrounding misconduct and abuse of civil liberties. The public record is replete with abuse. The public trust has deteriorated. Obviously, something needs to be done. Traditional oversight is not good enough because it always looks backward after the damage has been done. When an agency abuses statutory construct, whether intentionally or through malfeasance or through negligence, there needs to be consequences for bad behavior. The lack of any consequences for these abuses compounds the lack of trust. Let's make the system more accountable. As for oversight, how can there be effective oversight when so few clearances of congressional staff there is? Probably, of all the people that are doing oversight in the House side, I'd say there's not more than 15 or 20 people that have the clearances that really go. So how are you going to do effective oversight? And trust me, they understand that in the agencies. So 702 expires this year. The important provisions should not be lost if for no other reason than FISA was enacted to constrain. However, there's been abuse. If Congress decides to let it expire, which is their prerogative, then figure out a way to legislate a different mechanism to replace it. I stand ready to assist in any way I can. Thank you very much.
Thank you, Mr. Kiko. And now I recognize Ms. Goitain for your 5 minutes. Thank you.
Thank you, Chairman Biggs, Ranking Member Jackson-Lee, and Ranking Member Nadler, and members of the subcommittee. Thank you for this opportunity to testify on such an important topic. Section 702 was passed to enhance the government's powers to conduct surveillance of foreign terrorists. Today, according to the government, it's used to combat a range of foreign threats, including cybersecurity attacks, fentanyl trafficking, and espionage act. Of course, if that were all Section 702 were used for, we wouldn't be here today. The reason this authority is so controversial, and the reason it should not be reauthorized without far-reaching reforms, is that it's become a rich source of warrantless access to Americans' communications. How did this happen? Section 702 authorizes warrantless surveillance, and therefore it can only be targeted at foreigners abroad. But the surveillance inevitably sweeps in Americans' communications because Americans communicate with foreigners. If the government's intent were to spy on those Americans, it would have to get a warrant in a criminal investigation or a FISA Title I order in a foreign intelligence investigation. So to prevent the government from using Section 702 as an end run around these constitutional and statutory requirements, Congress did two things. It required the government to minimize the retention and use of Americans' information, and it required the government to certify that it is not using Section 702 as a backdoor to spy on Americans. These protections have proven to be meaningless. All of the agencies that receive Section 702 data conduct warrantless electronic searches of that data for the express purpose of finding and retrieving Americans' phone calls, emails, and text messages. The FBI conducted 200,000 of these backdoor searches in 2022 alone. This staggering number leaves no doubt that Section 702 has become a domestic spying tool, one that allows the government to circumvent the protections of the Fourth Amendment and FISA. Now, Congress and the FISA court have attempted to put some limits on this practice, but agencies have routinely violated those limits. In 2018, Congress enacted a warrant requirement that applies to a very small fraction of the FBI's backdoor searches. This requirement has been triggered roughly 100 times. By the government's own admission, the FBI has never once complied with it. The FBI has also engaged in widespread violations of its own rules for backdoor searches, according to the FISA court. These violations include searches for the communications of more than 130 racial justice protesters, thousands of people suspected of involvement in the January 6th attack on the US Capitol, 19,000 donors to a congressional campaign, and multiple US government officials, journalists, and political commentators. The starting point for any conversation about reauthorizing Section 702 must be a requirement that the government obtain a Title I order or a warrant before searching Section 702 data for Americans' communications. But that's only the beginning, because if Congress stops there, the government could exploit gaps in the law to obtain much of the same information, not just without a warrant, but without any legislative limits or judicial oversight. For instance, generally speaking, FISA only applies when the government collects information inside the United States or from US companies. This geographical boundary is a holdover from a time when domestic surveillance usually meant surveillance of Americans, and overseas surveillance usually meant surveillance of foreigners. But in the digital age, Americans' communications are as likely to be rooted and stored overseas as they are in the United States. Overseas surveillance can therefore have just as great an impact on Americans' privacy as domestic surveillance. Yet for the most part, the government writes its own rules for overseas collection. And those rules expressly permit bulk collection and backdoor searches. There are also gaps in FISA's exclusivity provision that allow the government to treat certain parts of FISA as optional. For instance, FISA appears to require the government to obtain a court order to collect American cell phone location information. But the government can and does obtain access to vast databases of this highly sensitive information by purchasing it from data brokers. There is little point in closing the backdoor search loophole if the government can simply pivot to other loopholes in the law. Meaningful reform of Section 702 will require a comprehensive approach to reining in warrantless surveillance of Americans. Thank you, and I look forward to your questions.
Thank you very much. And now we'll go to you, Mr. Shar, for your 5 minutes.
And Ranking Member Jackson Lee and Ranking Member Nadler and other members of the subcommittee. It's an honor to appear before you today on behalf of our civil liberties organization, the Project for Privacy and Surveillance Accountability, or PPSA. We work with groups across the spectrum to address government surveillance abuses and encroachments on the Fourth Amendment. And I'm here to urge you to treat the expiration of FISA Section 702 as a once-in-a-generation opportunity for Congress to reassert its rightful constitutional prerogative to broadly determine when, why, and how Americans can be surveilled by their own government. And to that end, with our allies, we have urged Congress to enact comprehensive reforms that implement 5 key principles designed to protect Americans' privacy without sacrificing our security. Today, I'll focus on just 3 of those principles and how they can help you bring all government surveillance of Americans within appropriate statutory guardrails and oversight. And by the way, although I represent Carter Page and many other clients, I'm appearing today only on behalf of PPSA. The first principle that we've urged flows from the consent of the governed concept articulated in the Declaration of Independence and then embodied in Article 1 of our Constitution. And it is that American citizens should not be subject to surveillance by their own government without their implied consent in the form of a statute duly enacted by their representatives here in Congress. Americans shouldn't be subject to surveillance merely at the whim of the FBI or any other executive official, none of whom has authority to consent to surveillance on our behalf. And yet, under administrations headed by both parties, the CIA, for example, has exploited technology-created gaps in FISA's reach to conduct a bulk collection program that sweeps up much of American sensitive data. Similarly, as we've heard, the FBI routinely conducts backdoor searches of information collected under Section 702. And as we've also heard, the government routinely buys our most personal information from third-party data brokers. And without a clear statute governing all surveillance activities, Congress will be doomed to forever playing whack-a-mole with the surveillance agencies. The second principle is that, as Ms. Goitain said, any government access to Americans' communications or other private data should be undertaken only pursuant to a probable cause judicial order. Such a warrant or other order provides at least some assurance that the government has a specific concern that justifies the surveillance. A probable cause order requirement, moreover, should not apply just to direct surveillance, but also to more indirect forms of surveillance, like searching for information about Americans in a database of purchased information or in the massive trove of data compiled under Section 702. On that point, you've already heard many examples of overreaching backdoor Section 702 searches, and I won't repeat them, but the potential for abuse of purchase data, including geolocation data and other Fourth Amendment protected information, is, if anything, even greater. But currently, neither of these indirect forms of surveillance is meaningfully constrained by statutory guardrails or judicial oversight. They should all be subject to a probable cause order requirement similar to the requirement for surveillance under FISA Title I. The third principle is that any surveillance of Americans should be subject to adequate mechanisms in both Congress and the judiciary to ensure accountability for compliance with governing law. And that's important because, as we know, the current system is rife with violations. The chairman mentioned earlier the DOJ Inspector General report that found so many violations of the requirements applicable to applications to the FISA court. And those problems highlight the need for an enhanced system of having civil liberties experts, or amici, advise the FISA court in sensitive investigation along the lines of the Lee-Leahy amendment that a couple of years ago passed the Senate overwhelmingly. More generally, any revamp of FISA must go well beyond ensuring that Congress has the tools to adequately oversee surveillance agency. That revamp must also include enhanced penalties for violating statutory guardrails, for lying to courts, for refusing to comply with statutory reporting requirements, and other meaningful consequences for misbehavior or stonewalling. As the people's agents, you can stop this game of surveillance whack-a-mole. You can do that by asserting your constitutional authority against an executive branch that under both parties is too often overbearing, and against the judicial branch that too often gives the executive an undeserved benefit of the doubt. Please don't let this rare opportunity slip away.
Thank you, Mr. Shar. And now recognize the gentleman from Florida, Mr. Gates, for his 5 minutes.
Ms. Goitain, many of my constituents will watch this hearing and they'll say, well, the Foreign Intelligence Surveillance Act, I'm not a foreigner. Why should that bother me? What would you say?
Americans' communications are swept up in enormous volumes, so enormous that the government won't tell us how big it is because it would be a very awkward number for the government to disclose. I suspect that's the real reason. And those communications are available to FBI agents without a warrant or a court order of any kind.
And you talked about these backdoor searches, and that's been an intense focus of the committee. Could you help define that for folks so they understand the risk there?
Sure. What a backdoor search is an electronic query of data obtained under Section 702. So the communications are obtained. They are placed into data systems at the NSA and then shared with the FBI, the National Counterterrorism Center, and the CIA. And then agents can run electronic queries of those data systems using identifiers associated with Americans. So using an American's email address, for example, they can plug that in, and that will return any communications that were obtained under Section 702 that have an American on one end of them. And
It
then,
almost feels like there's a digital file out there about millions of Americans. And I'm sort of wondering how, and we've tried to get straight answers from folks who work in the government about this question, but what we've learned is it's upwards of 10,000 people who can conduct some of these backdoor searches. Have any of your studies evaluated the breadth of individuals who can engage in this violation of our civil liberties?
no, we don't know the number, but I think
Isn't that scary? Shouldn't we? I mean, it seems like something we should know. How many people can do backdoor searches into information that was not collected pursuant to any probable cause or a warrant?
yeah, it would be a good thing to know, and one of the reasons why I think we should be curious about it is because the government has told the FISA court that one of the reasons for all of these violations we've seen is that FBI agents didn't understand the standard for those searches, and that standard is that the search has to be reasonably likely to obtain foreign intelligence or evidence of a crime.
Well,
that doesn't sound like rocket science to me, and that standard has been in place for 15 years.
But they break it. Well, I mean, I just read an order from the Foreign Intelligence, the FISC, the court, and the court said, well, you weren't just using these searches and queries to get legitimate law enforcement information. At times, people at the FBI were searching themselves, searching their ex-lovers, searching their neighbors in this system. And so it seems as though there's not a standard that's adhered to.
It's adhered to often in the breach. There were 278,000 violations of that standard in 2021.
I mean, if you've got 278,000 violations of the standard, as you've said, the breach is the standard in a lot of ways. So we have this tactical question coming up. We have FISA that is set to expire, and I believe we should let it. I believe the standard of violation of breach is so pervasive that the patient is not savable, that we have to design something totally different outside of 702. And then I have other colleagues who are like-minded in my desire to protect civil liberties, but who suggest tactically that the best approach is to try to insert strong warrant requirements. This is my 7th year in Congress, Mr. Kiko. I certainly don't have your experience, but I want to draw on it because I want to get your advice. I've gone down this road with the Cheneyistas and others who bring us to the precipice of reform, and then at the last moment, it seems as though the civil libertarians rarely prevail over those who purport to be defending national security, no matter how many violations of our liberties occur. And so would you advise a reform effort or an expiration strategy, and why?
Well, I would. That's a very tough question, and I know that's why you ask it. And I can actually see my preference would be some kind of reform effort with teeth and accountability, because there hasn't been any teeth and there hasn't been any accountability in the oversight that's been conducted. We're always at the end of the system. They say they're going to do something. It never gets done. 4 years later, we find out there's massive violations. Everybody comes, well, we're going to do it this time. But there's no accountability among the people that are breaking the law. There's no accountability among the administration. It doesn't matter. There's nothing.
Yeah, it sounds like there need to be penalties. Thank you for your testimony. I yield back.
Thank you. Chair recognizes the gentlelady, the ranking member, Ms. Jackson-Lee.
And thank the witnesses very much. Just a slight moment down memory lane, Ms. Goitain, something called COINTELPRO. I won't ask you to get in the weeds, but it was used extensively against Dr. Martin Luther King and the whole landscape of civil rights activists and workers to give minimal liberties to African Americans during the 1950s and 60s. And so here we are again with what was needed to be able to protect Americans. And I think it's important to indicate that the process was that if there was communication and it was with a foreign operative, foreign citizen, the FBI for Americans would not be targeting you, not supposed to be, but we're targeting that foreign citizen or the communications thereof. How did we mess up so badly?
Wow, that's a tough question. What I would say is that FISA, as enacted in 1978, required the government to obtain an individualized court order showing probable cause that the target of surveillance was a foreign power or an agent of foreign power when domestically placing a wiretap to collect communications between even foreign targets and Americans. And that was to safeguard the Americans' constitutional rights that they have in that communication. What Section 702 did is it got rid of that requirement. And it enabled the government to say that as long as it's targeting a foreigner, we don't really have to worry so much about the Americans' constitutional rights. Now, that's not actually what Section 702 says. It says, you're gonna pull this in, the American side of the communications, but you should minimize it. You should delete it, you should not share it. Unfortunately, that's not what has happened.
So that is, that's a crux of one of the elements of the problem.
Absolutely.
There this mountain piles up and no one feels any compulsion, not compelled to say, let me immediately send it into the incinerator, throw it into the trash, get rid of it, shred it, etc. Doesn't happen.
Right, and even if the FBI comes across Americans' information, or other agencies, NSA, CIA, that doesn't even seem to be foreign intelligence or evidence of a crime, they pretty much never get rid of it until it reaches the age-off deadline, which is 5 years. It's 5 years with a lot of exceptions, so it's 5 years or in many cases much longer.
Let me try to hone in on what Americans may be impacted by with respect to these cases. In this pile of information in which an agency has not complied with the guidelines that Congress put in place and or their own policies. To your knowledge, is the evidence found, or has the evidence found in this way, typically excluded in a criminal case?
Well, in most criminal cases, the government doesn't give the notice to criminal defendants that is required under FISA. There's been a long pattern of the government evading its notice obligations. And if the defendant doesn't know that FISA has been used, that Section 702 has been used in that defendant's case, there's no way the defendant can raise a challenge, let alone have the evidence excluded. And most likely, the way that the government has been avoiding this notice obligation is through parallel construction, which is a well-documented practice of essentially recreating the evidence using less controversial means. So one of the things that Congress should do, if and when it reauthorizes Section 702, is to prohibit parallel construction. If I could quickly speak to Congressman Gates's question, I think the problem with simply letting Section 702 expire is that...
I will allow you to do so. The chairman's going to give me a little bit more time to be able to answer.
No.
But if you'll go quickly.
I'll go very quickly. Is that Congress will then lose the opportunity to make necessary reforms to other surveillance authorities and to close gaps that are in those authorities that allow the government to operate without any statutory authority at all. And if Congress merely lets Section 702 expire, the government will shift its surveillance activities to these other methods.
So let me quickly get from you the singular change, other than what we just talked about, parallel construction, that we should be looking at.
Gentlelady's time's expired, but you may answer that question.
If I have any message for you today at all, it's that you cannot just go with one singular change. A warrant requirement for backdoor searches is necessary. It is far from sufficient. There are other reforms that need to be made, not only to Section 702, but also to overseas surveillance that currently happens without any statutory authority, to the practice of purchasing Fourth Amendment protected information from data brokers, and several other reforms that I mentioned in my written testimony.
Thank you. I yield back.
Thank you. I recognize the gentleman from Wisconsin, Mr. Tiffany.
Yeah, thank you, Mr. Chairman. The subject of this hearing, Mr. Chairman, is fixing FISA, correct? And so, with all due respect, Mr. Kiko, I heard the comment you made that was along the lines of that both parties agree. On one of the most significant abuses of FISA, we do not have agreement, and that was in regards to one President Donald J. Trump. It was abused, and Mr. Durham highlighted what an abuse it was of FISA, and we have many people, including on this panel, that still will not recognize that, and that is dangerous for the American Republic, because if you have a Praetorian Guard that thinks they can take down a president, are we all free? Are we all free? Mr. Turley, building off from Mr. Gates's question, so let's say we don't authorize, what will happen? Let's say we didn't, will there be things that fill in the gaps? Do we have existing law?
Well, thank you for asking that question, because there is what economists sometimes call a path dependency that can set in with these types of programs, that you can't imagine not having 702. I can, because 702, and many of the members of this panel can, because we were here. You were in Congress. I was testifying when 702 was created. So there was an existence before 702, and Rome did not burn, that you have a system that can handle it. The question is whether Congress feels that these abuses are so serious that you want to use a rule, that if you abuse it, you lose it. That is, this is not the first time the FBI has come before you and said, oops, we misunderstood the law. Oops, we did millions of improper searches. Oops, we actually violated the privacy of citizens in exactly the way that people said would happen. At some point, Congress has to decide whether 702 was a good path to take. If it decides to reauthorize 702, the solutions are very, very clear.
Mr. Turley, if the people are not honorable in those agencies, is it even fixable?
Well, part of the problem I had with Director Wray's testimony this week is when he talked about FISA, he kept on saying that was that earlier director. Well, the director may have changed, but the people in the FISA system have not. There's been a consistent culture of violations here that go back throughout the history of FISA. And this gets to, again, this sort of premise that was the flaw of FISA of trusting the government to act on good motivations. And I think that it's repeatedly shown, quite frankly, it cannot be trusted with that level of discretion.
Unfortunately, I only got 5 minutes here. You want to get a couple more questions, Mr. Shar. Mr. Gates once again said, tactically, what should the reforms be? What would be one reform that you would say needs to be done if Section 702 is left in place? Turn your mic on.
Several of us have come up with a list of reforms, and there are over 25 of them. Perhaps the most important is the warrant requirement, the probable cause requirement that we discussed earlier. And if I could just briefly answer the question that you asked earlier, Congressman, as a former White House counsel lawyer, the answer that I would give to your question as to why it would be a mistake just to let Section 702 expire is that you then have a statutory vacuum which the executive branch loves. If you're a lawyer in the White House or the Justice Department, you're going to ask, the question you're going to ask is, if we do this, will we be violating any law? And if there's no law on point, your inclination is going to be to ask, well, does the president have an inherent authority to do this thing that the intelligence community wants to do? And of course, they tend to read presidential authority broadly. And so if there's no statute that governs the issue, you're basically going to be opening the door to the White House and Justice Department lawyers to come up with creative
So you're concerned
rationales.
that we'd be ceding authority to the executive?
Absolutely. and it's not their role.
So, what if there was a penalty of removal of qualified immunity for somebody that abused this?
I think that's something that ought to be considered.
Okay, I got to get one more question in here. Ms. Goitain, Mr. Turley did a terrific job of anticipating my question. Did you hear the testimony of Director Ray?
I did not. I was busy preparing for this hearing.
Well, I would just say to you that you were incredibly prepared, and we really appreciate that. Mr. Chairman, I just want to say thank you for putting together this panel. It's one of the finest that I've been before.
Thank you. Thank you. They have notified votes. They've called them. What we're going to do here, just so everybody knows, is we're going to go to Mr. Nadler for his questioning, and then we're going to recess until after the votes, which would mean I would anticipate somewhere between 11:15 and 11:30 we'll be back in this room. Sorry about that interruption. And with that, Mr. Nadler, please.
Thank you. Let me first say that with respect to what Mr. Tiffany said, we may have a disagreement over whether FISA was abused in a certain case or not with respect to the former president. That doesn't affect our deliberations now. We all agree that FISA has been massively abused, and we've got to fix it. Mr. Kiko, and the idea of eliminating qualified immunity here is a good one. I'd like to eliminate qualified immunity entirely. Mr. Kiko, in the 3 months since this committee last held a hearing on FISA, we learned that the FBI conducted unminimized warrantless backdoor searches of campaign donors, George Floyd protesters, and many others. If the FBI sought to search Americans' communications, no matter the reason, they would normally need a warrant under the Fourth Amendment. Could you briefly explain to us why the court has found warrantless searches of the 702 database to be acceptable under the Constitution? Mr. Kiko.
I don't think a warrantless search is acceptable under the Constitution. And that was what was anticipated when the Fourth Amendment was created.
No, we agree on that. My question is, why has the court found warrantless searches of the 702 database to be acceptable under the Constitution?
I haven't looked at that particular question, so I would ask a panel member to
Anybody else? Ms. Goitain?
I'd be happy to answer that. The FISA court has found that warrantless searches are constitutional. The FISA court has essentially said as long as the initial collection was lawful, then you apply some kind of lower standard to analyzing the queries rather than treating it as a separate Fourth Amendment event. However, Section 702 has recently made its way to the regular federal courts. And I say recently because for many years the government was not providing notice to criminal defendants, so there was no way to raise the issue. But in the past few years, regular federal courts have had a chance to look at this question, and there is a divide among those courts. You have 4 district court judges holding that these searches are constitutional, and then you have 4 appellate court judges expressing serious constitutional concerns. The only federal appellate court to rule directly on this question was a unanimous 3-judge panel of the Second Circuit, which held that you do have to treat the query as a separate Fourth Amendment event, subject to its own reasonableness analysis. And the Supreme Court has made clear that warrantless searches are presumptively unreasonable unless they fall within an established exception to the warrant requirement, such as consent or exigent circumstances. The Second Circuit remanded to the district court to conduct that analysis. So the courts, it is far from settled that these queries are constitutional.
And Mr. Ranking Member, could I just add one thing as well to that, and that is this was a reference to the Hasbarami case in the Second Circuit, and I agree with everything that was being said. One of the barriers that we see in federal court is that people have been denied standing in order to challenge these issues.
Ms. Goitain, the number of searches conducted among U.S. person identifiers went from 3.4 million in 2021 to less than 120,000 in 2022. Can you explain what remedial measures the DOJ put in place to reduce the number and whether you consider these changes sufficient to protect Americans from unwanted surveillance?
Sure. The FBI imposed some new training requirements, some new oversight requirements. It changed its data systems in various ways, and these changes resulted in the searches, as you say, going from 3.4 million to 200,000 searches. Now, I would say that one warrantless search of Americans' communications is too many. 200,000 Warrantless searches, that's 500 warrantless searches for our communications every day. That is just a jaw-dropping number. And the fact that the FBI seems proud of that number really tells you how little regard they have for American civil liberties. They have made these changes according to the FBI's own internal study. Non-compliance has been reduced to 4%. I think there are a lot of reasons to question that number, but even if you accept that number, 4% of 200,000 searches, that's 8,000 searches every year that violate the FBI's own low standard.
Thank you, Ms. Goitain. How can FISA be modernized to protect America's communications that are inadvertently acquired through Section 702? What would be the impact of such changes on our national security? But how can they be, what should we do, in other words?
Right, so I think the solution is to require a warrant or a FISA Title I order in order to conduct these queries, and the government has put forward absolutely no evidence and no reason to believe that that would harm our national security. After all this time, the government has managed to come up with 3 examples of situations where U.S. person queries were useful. The government has been very vague about exactly how those queries happened or were used and how they produced the benefit that the government is claiming. But more importantly, the government has given no reason to think that a warrant requirement or a Title I order requirement would have prevented the queries from occurring. So for example, there's the Colonial Pipeline ransomware attack. In that case, the queries took place after the attack. So there would certainly be probable cause to support any query that would return evidence of a crime. And similarly, there were queries to try to identify and protect
The gentleman's time has expired.
potential victims of assassination plots. And I would argue that surely these potential victims would have consented to a search had the FBI bothered to ask.
Thank you. I yield back.
Thank you. And again, thank you to the panel. Thanks for indulging us to go vote. And we hope everybody votes with me. Anyway, we'll be back probably about an hour-ish, and feel free to make yourself comfortable here.
Agree. I wholly agree. And the FBI, on the other hand, has abused its FISA authorities and violated America's constitutional rights. And in several investigations and audits, the DOJ Inspector General Michael Horowitz and Special Counsel John Durham exposed the extent to which the FBI violated its FISA authorities. And for example, in 2019, the OIG issued a 478-page report finding that the FBI has abused its FISA authority to illegally surveil former Trump campaign associate and American hero, Carter Page. The report found 17 significant errors or omissions and 51 wrong or unsupported factual assertions in the applications to surveil Mr. Page. The FBI relied upon uncorroborated information to support its application to surveil Mr. Page because they wanted to keep, in my opinion, Donald J. Trump, the greatest president in my lifetime, from office. And per the report, the FBI cherry-picked facts to support its application, ignored exculpatory evidence, and even doctored evidence presented to a FISA court judge to support its surveillance against Page. The FBI's FISA applications to surveil Trump associate Page were based almost entirely on the debunked allegations in this Steele dossier. There was no probable cause. And I think it's very important that we go through. Mr. Carter Page, what an American hero. 1993, graduates from the Naval Academy, so wanted to serve his country. He worked as an intel officer for 5 years. And then you go forward from 93 to 2000, he begins working as an investment banker in London, making some money. 2004, gets promoted, moves to Moscow. And that's where things kind of get interesting. 2007, Page becomes an internal energy consultant in Moscow and London. And then in 2008, the CIA, they begin debriefing Page about his contacts with the Russians. 2000 now FBI counterintelligence interview, they interviewed Page, in which Page told them he was reporting information to the CIA. So back in 2009 already, the FBI, the CIA, they know who Mr. Carter Page was. In 2013, some Russian agents, in January 2013, some Russian agents approached Page in an attempt to cultivate him as a source. He rejects, of course. In April of the same year, the FBI records one of the Russian agents complaining about Page because Page wasn't working with him. He wasn't going to do anything for the Russian agents. He's an American hero. In June of the 2013, the FBI interviews Page again. And Page said he was working and he has spoken with the CIA. And Page agrees to cooperate as a key witness in the FBI undercover investigation of the Russian agents that want to turn him. So he's working, he's doing everything he can for his country, as he has when he started back in the Navy. And then it gets interesting. March of 2016, Page meets with the FBI agents and federal prosecutors about their case against the Russian agents. And one of those Russian agents was found guilty, spent 30 months in prison. That couldn't have been done without Carter Page. Then, all of a sudden, this is where things get really sour. March of 2016, Page joins the Trump campaign as a foreign policy advisor. In April of 2016, the FBI headquarters advises New York field office to investigate Page. A couple months later, in August 2016, FBI headquarters opens investigation of Page and prepares a request to eavesdrop him under FISA. August, the CIA sends a memo to the FBI headquarters and advised the Crossfire Hurricane team that Page was an operational contact for the CIA for 5 successful years, 2008 to 2013, and the FBI does nothing. They do nothing with it. What do we know? The FBI withheld this information from the FISA court, and the court approves the FISA warrant and secretly surveils Page. Wow. Wow. So he's an American hero until he joins the Trump team. And you wonder why people up here feel that the FBI cannot be trusted and why we say that they have weaponized the FBI to go against the American people, specifically with a dissenting point of view, like Carter Page and Donald J. Trump, and they haven't stopped yet. They continue to go up against Donald Trump, whether it's Mar-a-Lago, whether it's indictments up there with the nut job in Manhattan. It's just horrible what the FBI, we have to rein them in. I will not support the idea of reauthorizing 702 for the FBI until they get their house in order. With that, I yield back.
Thank you. Chair recognizes the gentlelady from Pennsylvania, Ms. Dean.
Thank you, Mr. Chairman, and I thank the ranking member for having this important hearing today. an important moment of bipartisanship in the understanding that the FISA application has gone horribly wrong. It is our responsibility to do something about it. So I thank all of the witnesses for being here today, for your expertise and your historical understanding of where we are and the grave moment that we're in. The Foreign Intelligence Act, FISA, the legislative branch, we're entrusted with making the laws of the United States. It's our job to decide what the rules should be, delineating fair from unfair, safe from unsafe. Sometimes these decisions are straightforward and easily guided by the Constitution and common sense. Other times the decisions are more difficult. It feels like we're in one of those places now with a clear-cut understanding that the abuses of the FISA applications and queries are unacceptable. We know we have a responsibility, as do the agencies, to protect our national security, to protect us against crime anytime we can possibly do it. But we must always protect civil liberties, people's rights to privacy, our constitutional rights. Ms. Goitain, I was interested in your very eloquent history of what's going on here and what has happened. We do need to review the FISA process. What are the most, if you had maybe 3 areas of reform, what would be the most important? I know it's denser than that, but what would be the most 3 top areas of reform?
I've been trying to narrow it down a little bit because I know that that's helpful. It's difficult. There's a lot that needs to be done, but I think I can at least narrow it to 3 buckets. And the first bucket is ensuring that Section 02 works as intended, and that means that it's not a domestic spying tool. For that, we need to have a warrant requirement or a requirement of a FISA Title I order before the government conducts U.S. person queries of Section 702 data. Part of the Section 702 reform also has to be narrowing the scope of permissible surveillance so that the government is not allowed to conduct surveillance of foreign targets who do not reasonably pose any threat to the United States or have any information about a threat to the United States. That is actually a vicarious protection for Americans' privacy, because the larger the scope of permissible foreign targets, the greater the volume of incidental collection of Americans' communications. So that's the Section 702 bucket. Then I would say that Congress needs to complete the modernization of FISA by ensuring that Americans' communications and Fourth Amendment protected information are protected from warrantless surveillance regardless of where in the world the government obtains that information. And then finally, I would say that the Congress has to close the data broker loophole. And while we were on break, the House passed by voice vote a bipartisan amendment co-sponsored by Representatives Jacobs and Davidson, and with a long bipartisan list of co-sponsors, which I'm not going to list because I'm afraid I'll forget someone by accident. But the House passed an amendment that would prohibit the Department of Defense from buying its way around the Fourth Amendment and obtaining Americans' Fourth Amendment protected information by buying it from data brokers. That is proof of concept. Congress can do this, and Congress now needs to do that for all federal agencies.
That's very helpful. Mr. Kiko, thank you too for your testimony and your work on this. We talked about whether to sunset and allow it to expire, Section 702, or to reform it, as we've just had some conversation around that. What are the consequences of allowing 702 to simply expire later this year?
Well, I think allowing it to expire, you're turning over the keys to the to Article 2, to the executive branch. And we've had enough experience to know that even when they have a statute, there's ways to weasel around it. And I just would be very, Article 1 is the Congress. They're the ones that establish the law. And we're going to have to, my experience would be to draft something, but you're going to have close oversight. You're going to have to bring the administration to heel, for the consequences of abuse, but also we don't have to have it read as broadly as it is for data purchases and for all this other stuff that they've been somehow figured out to have jurisdiction over. So if you could narrow that and just, but really have tight oversight and also consequences for people and agencies that don't follow what the law is.
I thank you both. I thank you, Mr. Chairman. My time has expired. I yield back.
Thank you. Chair recognizes the gentleman from California, Mr. Kiley.
Professor Turley, in your statement, you quoted Justice Brandeis's famous formulation of privacy as the right to be let alone, which I do believe is indeed one of the rights most valued by Americans, and that most Americans would be horrified to hear of the government having access to their private communications. There's something really fundamental about this separation between the public and the private, the idea that each of us has a sphere of personal privacy that is inviolable, that goes to the heart of what it means to live in a free society. But sometimes you hear a contrary view that, well, if you're not doing anything wrong, what do you care if the government has access to this? What would be your response to that?
Well, thank you very much for that question. What's interesting about the quote that you just cited is that this was part of the Katz-Olmsted line of cases. And Katz said that the Fourth Amendment's there to protect persons, not places. It got rid of the trespass doctrine as the key test for whether your rights are violated. We've sort of returned to that because the location of a lot of this data, if it's abroad, for example, or it's routed through an international source, suddenly loses its protections as a citizen. So to answer your question, how does that impact you? The answer is that 702 and the abuses under that section impact free speech, associational rights, a host of other constitutional rights, because it creates a chilling effect that if citizens know that their communications are part of a massive data bank that the government can search and piece together who you've talked to, who you sent to, you begin to live in this fishbowl society. That impacts us as citizens. It impacts how we exercise rights, which is what Brandeis was referring to.
And Mr. Shar, or Mr. Shar, I should say, right?
Share, yeah,
Share.
like the singer.
We've been talking a little bit about how this right was, put into our Constitution by our founders in the form of the Fourth Amendment, and how a lot of the jurisprudence and our understanding of the Fourth Amendment is rooted in this idea of a reasonable expectation of privacy. And so we've heard that the law, at least as far as the courts are concerned, is a little bit unsettled when it comes to how that applies to the situation we're talking about today. So in your view, is that a lens that Congress should look through when deciding what to do about FISA, the reasonable expectation of privacy that Americans have, and how should that apply to the gathering of information under Section 702?
Well, 2 points. First of all, while Congress should take account of what the courts have said on the application of the Fourth Amendment in this setting, I don't believe, with all respect, that you as members of Congress should feel bound by what the courts say. All of you, and I apologize if this comes across as a lecture, but all of you have taken an oath to support and defend the Constitution of the United States, not the interpretation of the Constitution by some federal district judge in the Western District of Wisconsin or wherever he or she may be. And you have the ability, and I think the right and the duty under the Constitution, to reach your own conclusions about what the Fourth Amendment requires. But secondly, even Congress has an important role to play in determining for the courts what is a reasonable expectation of privacy, and when do the people of the United States have a reasonable expectation of privacy? And even if some courts don't think that we have a reasonable expectation of privacy in our electronic data, which, as we've heard, may get sold to data brokers and then sold to other people, Congress can step in and say, no, we think the people of the United States do, in fact, retain a reasonable expectation of privacy in their private data, even if it's held by Google or Amazon or somebody else. And we, the Congress of the United States, believe that Americans retain an expectation of privacy in communications that have been collected pursuant to 702.
Well, that's right. And so could we take the analysis a step further? And so I think most Americans would understand we live in a dangerous world. Intelligence gathering is very important. Sometimes aggressive tactics are needed. And it's possible that on occasion, information can be incidentally collected. So the question becomes, once that information is there and in the government's hands, what do you think is the reasonable expectation of Americans as to what is done with that information, how long it's kept, who can access it? Because that's really, I think, the question when it comes to reforming FISA that we need to consider.
Well, certainly, and if people have not expressly consented to have that data collected and put into the 702 database or wherever else it goes, I think it's fair to say that they should retain an expectation of privacy in that data, even if somebody else has it, and therefore Congress can say, consistent with the Fourth Amendment to the FBI, if you're going to search that database of purchase data, or if you're going to search the database of 702 derived information, you need to get a probable cause order from a court.
Thank you very much. It's great to see the bipartisan agreement on a lot of these principles, and I yield back to the chair.
Thank you. Chair recognizes the gentleman from Georgia, Mr. Johnson.
Thank you, Mr. Chairman. Having practiced criminal defense law for 27 years and acted as a judge for 12 years prior to my 17 years now in Congress, I understand Fourth Amendment principles and understand the concept of a reasonable expectation of privacy, but I cannot wrap my head around the concept of a reasonable expectation of privacy in data that has been acquired over the open market by anybody who wants it, like Russia or China or Iran or North Korea. That's data that is purchased every day by our adversaries. Why should not our own government be able to acquire that same data that we certainly have no reasonable expectation of privacy in, given the fact that it's on the open market? However, we in this country can certainly rely upon the Constitution and its principles to protect our privacy, especially when privacy concerns bump up against security concerns. We've lived through harrowing terrorist attacks on U.S. soil and through attempts by foreign actors to meddle in our national elections. That's why, while taking affirmative steps to protect our civil liberties, we must give our intelligence community the tools it needs to protect us. Section 702 of the Foreign Intelligence Surveillance Act is one of those tools necessary to protect our national security. Due to the classified nature of much of the work that's done under Section 702 FISA authority, Americans will never know how it has kept them safe, the degree to which it has kept them safe. They will, through politicians, hear of problems with implementation of the legislation and demonization of those who would access that information to protect us. In the real world, law enforcement can patrol the street to monitor suspicious activity. They don't need a reasonable expectation of privacy in order to be out on patrol. We need to bring real world processes to the cyber world. And Section 702 allows us to do that, letting law enforcement patrol the information highways to neutralize threats. However, just as cops have certain limitations, the intelligence agencies have limits on their ability to search the Section 702 database when it comes to U.S. person identifiers. If the agency's investigation is related to national security, then a database search using U.S. person identifiers is allowed when the agency believes it is, quote, reasonably likely, end quote, that such a search will retrieve foreign intelligence or evidence of a crime. And if the agency's investigation is unrelated to national security, then the agency must get an order from the Foreign Intelligence Surveillance Court before it can search the database using U.S. person identifiers. In the past, it seems that the FBI has fallen short due to, among other things, lack of proper training on the limitations imposed on them by law. In this day and time, when politicians recklessly demonize government in general, and the FBI and DOJ in particular, the public is susceptible to claims that the FBI willfully defies the law, abuses its power as a regular course of conduct, and as some have argued, is generally, quote, bad. I respectfully disagree with the assessment of the 38,000 employees of the FBI including special agents and support professionals, many of whom put their lives on the line every day to protect us from danger, both foreign and domestic. And I would also point out that it's not about bringing this administration to heel. These FISA excesses existed during the Trump administration and before. In the past, I'm heartened to see that the Department of Justice is working hard to improve agency compliance with the civil liberties protections in Section 702. I look forward to continuing the dialogue on how we can improve compliance with Section 02, how we can improve the act itself. And with that, I will, well, I don't have time for
Yeah, you can't yield anything back. You don't have any time left. But thank you, though. Yes, I knew you did. And we'll now recognize the gentlelady from Florida, Ms. Lee.
Thank you, Mr. Chairman, and thank you to all of you for being here today as we work to identify solutions and improvements to this process. For us to have a panel such as this is extremely helpful. So we are very grateful to have your years of experience and your background working in this subject matter here with us today, both your written testimony and what you've shared with us during this hearing. We have, a number of us commented, and I think it bears noting again here today, the good work and integrity of so many of the men and women of the FBI who work out in field offices across this country. However, that said, we are of course here to address a very specific and serious concern, which is the misuse of FISA and surveillance techniques, and I believe there's broad agreement here that we have much needed reforms to discuss. I'd like to go back, Mr. Shar, to some of what you've testified about in parts of your written testimony that you submitted to us. So we know that 702 is providing the FBI with access to a large amount of information about Americans. But one thing that you have touched on, when we look at the concept of potentially creating alternative statutory schemes or potential revision, the concept that the government is also utilizing other sources of information, private data, other things to essentially surveil or gather information about Americans. I'd like to hear more about that subject and what you would propose, if anything, we should be doing to try to monitor or curtail that practice.
I assume that you're referring to the purchase of data,
Yes,
which is, in my view, an equally, if not more serious problem than the vast trove of information that's collected under pursuant to Section 702. And certainly both of those enormous databases together can be an enormously powerful surveillance tool. And like any other surveillance tool, it should be subject, in my view, to a judicial order with a probable cause requirement. I think that's the most important thing that can be done. I don't think any of us here on the panel are disputing the wisdom or the ability of the FBI to collect the underlying data. Yes, in many instances it's broader than it needs to be, but the key event is not so much the collection of the data as the searching of that data using identifiers that are specific to American citizens. In my view, that constitutes a search for Fourth Amendment purposes, and even if you disagree with that, it's still an important event to the privacy of an American citizen, and is therefore something that Congress can and should regulate very closely.
All right. Thank you, Mr. Shar. Professor Turley, I'd like to go back to something you mentioned earlier as well, and that is the concept of making the FISC court process more adversarial, adding an adversarial component of that or having an amicus involved in that process. Would you elaborate for us on how you think that type of reform could be implemented and how that might look?
Thank you very much for that question. The Congress years ago implemented this amicus process by which the court can reach out by what the Congress described as novel questions to get the assistance of essentially a third-party view, separate from the government. That has been relatively underutilized. As far as I know, there's no indication it's ever been used in an individual case where the FISA court says, can you look at this application? And what we know is that when we actually put those applications under a spotlight, which is relatively rare, as the chair mentioned, out of, I think, 29 cases reviewed, 25 of them were in error. So there's obviously a need for some additional viewpoint. I don't think that's going to be achieved with any amicus curiae. I think that what you really need is this sort of concept of a special advocate, a formal office that has the ability, among other things, to bring a case to the appellate FISA court, to say that there's a problem here that you should reveal or review. I think that would be very useful to have an actual privacy advocate with security advocacy. If you're going to have a secret court, let's make sure both are represented.
Thank you, Professor Turley. And Mr. Chairman, I yield back.
Thank you. Chair recognizes the gentleman from South Carolina, Mr. Fry.
Thank you, Mr. Chairman. You know, this is incredible. I mean, we finally, we've been fighting all week on the floor on the NDAA, and in this committee, it's always a knife fight, it seems like. But in today's hearing, we have really unanimous support for fixing this process. We're letting it expire, but there's a recognition across the entire country that this needs to be fixed. You know, what's perplexing to me, and we just had Director Ray come in, Professor Turley, you alluded to that earlier, who, if you ask agencies, all is well in the land of Oz, and that's just really not the case. We know that the FBI and other agencies have abused FISA to the nth degree. We know that they continually spy on Americans without a warrant. We know that they end around and they use data collection and geotagging and geolocation to look at the activities of Americans. And at the end of the day, you know, I look back and Professor, you cited the Federalist Papers. You know, we're a nation of laws. We're not some Orwellian dystopia where these things are appropriate or even allowed, but we've allowed them to happen. And I think to the point of the entire panel, we really need to get a handle on this in a pretty aggressive way. Professor Turley, I want to start with you. To hear the FBI talk about it, we should be celebrating that we went from 2 million illegal search queries to 200,000. Do you think this is cause for celebration?
No, it's like a bank robber saying we're hitting smaller banks. I mean, the problem is that you're engaged in something you're not supposed to do. Look, the thing that we have to keep in mind is that all governments are information junkies. That is consistent across all types of government, whether they are democratic or authoritarian, they're information junkies. They want more information. It's not necessarily for nefarious purposes. It's that they want data. They always do. And so this impulse will exist, and it will grow unless you restrain it. I was baffled by the director's testimony. When he said that he wasn't even aware of what parallel construction was, I was really taken aback, because that's a core issue in these FISA debates. It's been an issue for years, and I just looked in disbelief when he said, I'm not sure what that might be. What that might be is a very serious threat to privacy. It's existed for years. It essentially replants material in order to create a different origin, and its purpose is to hide the original origin from courts. And as someone who's litigated national security cases, I have to tell you that these cases are riddled with this type of sleight of hand. And I'm usually the cleared attorney in national security cases. I've had national espionage, terrorism cases. And when you hit a FISA line, all the lights go off. I mean, the government gives you nothing. But the other thing that I want to emphasize about these commercially available information is it has another insidious problem. And there's what happens is the government often wraps commercially available information into FISA applications, and then everything gets iron-plated under FISA. And when people like me finally see the applications in the SCIF, we find it's loaded with material that should have been disclosed to defense counsel or to trial counsel.
Right, so this is nothing to celebrate. I mean, 200,000 violations of the Fourth Amendment is not really a good cause for celebration. You know, Professor, I think you hit on having a special advocate and strengthening that. I think that's a great step. What in your mind are other reforms that would be crucial to fixing the FISA problem that we have in this country?
Well, Congressman, the most important one is where we should have started and ended this debate in '78. That is, you cannot engage in a query or search of a U.S. citizen without a warrant or Title I order, period. I don't think it should matter where that occurs. Now, it's true, the extraterritoriality of the Fourth Amendment has not been supported by the Supreme Court, but you can support it. You can support the rights of U.S. persons abroad. That creates a very clear line. When I talked about letting the provision sunset, I'm saying that when it sunsets, you make clear that all searches or inquiries, wherever they are, of a U.S. citizen by a U.S. agency must be accompanied by a warrant or Title I order,
right.
Period. And they can find a way to try to get around that, but that's the brightest of bright lines.
Mr. Shar, real briefly to wrap up, I'm also concerned that even if we fix this, that the administration, a future administration, would just end around this by virtue of executive orders. So how do we deal with FISA and reforming FISA when an administration could just go around it? What would you suggest in that sphere?
Gentleman's time's expired. You may answer the question.
I think the short answer is 2 words. Any statute needs to make clear that whatever Congress specifies as an appropriate search has to be the exclusive means of obtaining the information that's covered. And if you're a lawyer sitting at the White House or the Justice Department, you feel an obligation to be sure that the president that you serve takes care that the laws be faithfully executed. And if it's clear in the law that there's one exclusive way of getting the information at issue, you're going to feel some obligation to be sure that your boss proceeds in that way. But if there's a statutory vacuum, that's where the problems arise.
Gentleman's time has expired. Now, I haven't taken my 5 minutes of questioning yet, but I'm going to go ahead and do it. I'm going to limit it to, I think, 3 questions. And
I have the gavel.
you took the gavel from me. Yeah, she's going to pop me with that gavel. Okay, we're going to start with you, Mr. Turley, please. Let's get with this. Capacity of state and district courts to keep records and information sealed. That's one of the critiques we have about moving away from a FISA court because, oh boy, there'll be leaks as if there's been no leaks in the current scheme. So tell me your experience there, and is it possible for state and federal courts to keep information sealed?
Yeah, I always hear this objection, and it has no support at all. I deal with national security cases through regular Article III courts. Throughout the years, they have SCIFs, they have training, they're cleared. There aren't these allegations of leaks. The issue with the secret court is that no one's objecting that you can have a secret court in the sense of a giant SCIF where secret proceedings can occur. You can even have judges that are selected and trained for that purpose. The question is whether the standard for U.S. citizens and U.S. persons should be different in that courtroom. And I have never accepted that to be the case. I don't see an exception under the Fourth Amendment.
Right, I appreciate that, and I'm in agreement with that. And Mr. Shar, I'm going to go to you next. The gentleman from Georgia kind of intimated that somehow data collection and querying is similar to an officer in a patrol car driving around and observing suspicious activity, maybe making a Terry stop, or whatever you want to call it. But how is this different, and why should we equate this more like to a wiretap rather than a stop and frisk?
I think it is very much more like a wiretap. I mean, yes, if you're a police officer, you have a right to be on a highway and watch what goes by, but that doesn't mean that you also get to have a helicopter flying over the neighborhood and taking pictures of everything that happens in every home in that neighborhood. And so, by all means, I think the wiretap analogy is the right one to use, because that exactly is what 702 is doing, is it's taking a stream of data, a massive stream of data, and just pulling things out of it, and even if it's appropriate to collect the data, there need to be Fourth Amendment protections when it comes to searching that data, especially
Just as you would have in a wiretap. I mean, when you narrow the search down, you've made it particularized. You've targeted somebody.
Right.
You're going forward and getting a warrant, right?
Right, and searching a database with somebody's name or other identifying information is more analogous to a wiretap.
And so I want to get to this other thing too, Ms. Goitain, and that is dealing with purchased information. And I think Professor Turley kind of got to it a little bit, is that they wrap it up. And when we've been briefed by the FBI on this, they talk about multiple databases that they're using, and then there's a wall that's created. Why should we prohibit the use of purchased material when we know other nations are using it?
Well, that's an important question. And let's be clear that we are talking about material that the government would need a warrant or a court order or a subpoena if it were compelling the production. So we're talking about sensitive information about U.S. persons. The reason the government can buy this from data brokers is because there are loopholes in the law. The law does prohibit phone companies and internet companies from selling this type of data to the government. But that law is from 1986, and so it doesn't address digital data brokers. They didn't exist back then. So there's this loophole where the companies cannot sell it to the government. They can sell it to data brokers. The data brokers turn around and sell the same information to the government at a handsome profit. So the information is laundered through a middleman. Now, we should be concerned about the fact that foreign governments can get this information. Congress absolutely should act on that problem, and the Brennan Center is in favor of comprehensive consumer data privacy legislation. That should not stop Congress from acting now to make sure that our government can't exploit this loophole, because when the U.S. government is obtaining American sensitive information, there are risks and harms to American civil liberties that go beyond what can happen when private entities can get that information, or even foreign governments, because the United States government has coercive powers over American citizens that private companies and foreign governments do not have. The ability to put us in jail, the ability to deport people, to tax you, to fine you, to put you on a no-fly list, to withhold public benefits. There are all kinds of ways in which the government can impact our liberties. And for that reason, the Fourth Amendment applies to the U.S. government, not to private actors, not to other governments, and Congress should make sure that the U.S. government is honoring those Fourth Amendment protections.
Well, my time has expired, and I thank each one of you. You've provided us with some information, and I think is vital, a lot of comments. And what I would ask of you is, as we go forward, we may have ideas, legislation that we want you to review. Please make yourself available. We appreciate you making yourself available.
Mr. Chairman.
Yes, and I believe there's some unanimous consents?
Yes, there are. I'd like, in tribute to Ms. Goitain, but I'd like to unanimously submit into the record Brennan Center Bipartisan Coalition responds to the FBI's new policies under Foreign Intelligence Surveillance Authority as unanimous consent. And under epic.org, July 13, 2023, new FBI procedures under FISA Section 702, out of touch with the extent of abuse, gravity, and privacy threat. And I think I will yield on those two items as unanimous consent to submit
Without
them into the record.
objections, entered into the record.
With the collegiality that we will work together on the best solution of this matter. And Mr. Chairman, just want to put it on the record, we are facing in the next decade artificial intelligence. And I yield back.
Thank you so much. And with that, I appreciate everyone being here, and we are adjourned.